Just before Carolyn addresses you on the recent decision, which is an interesting example of some of the general principles that Adrian was talking about, I thought I might just take 5 or so minutes to give you some practical examples or make some practical points based upon the general principles that Adrian spoke about. The first one I'd like to talk about is the issue of dominant purpose. In my practice, I regularly act for large insurance companies and large corporations that are involved in legal disputes, usually building disputes or professional indemnity type disputes. And before they come to see me, regularly because of the way they organise their organisations, they will have had investigatory reports undertaken by somebody. In the case of insurance companies, it's loss of justice reports, and in the case of large organisations, there will be a corporate structure where people investigate issues before they spend a lot of money on lawyers, which is perfectly understandable, but you then have a problem regularly where an enthusiastic investigator or an enthusiastic senior executive has been very candid in preparing a document which sets out the strengths and weaknesses of a client's position and gives bush lawyer type advice. We're probably, a lot of us, and I hear the sniggering, we've had that experience. And then when you come, and they may well be misconceived in what they say. And then you've got the problem when down the track your solicitors come to you saying, we've got to do the affidavit of documents, and look, this rather unfortunate document's been prepared that might contain some poor opinions or some misinformed opinions about the case. And the client at that stage will say, well, of course, that was prepared for giving to you or giving to the lawyers. Whether that's right or whether that's wrong is often a very vexed issue. And so if you do act for large corporations or insurance companies, it's really important that you impress upon them from a corporate strategy point of view that they understand that it's not necessarily the smartest thing to do to have detailed investigations undertaken prior to the retainer of lawyers. It happens a lot. And then the problem is these people think they are bush lawyers and express opinions in their documents that when they're sitting before somebody like me and I'm grilling them about the fact, well, why did you say that? Because did you know about this, and they all go, no, of course I didn't, so therefore, of course I was wrong. And then you've got the problem of telling them, well, in fact, what was the purpose of preparing that document? And quite often it's, well, it was to give to the lawyers, but it was also to tell businesses to what happened so they could come up with a strategy to fix it in the future. And as soon as they start saying that, the case that Adrian was referring to puts you in a difficult position. So the moral of the story is to make sure that if you act for those sort of clients, they're aware of the risk and potentially encourage them to not engage in the process. That's the first point. Second point, about the reference to counsel's advice or lawyer's advice in a document, the effect of which you still far too often see, based upon, you see in an affidavit, based upon counsel's advice we did the following in an affidavit, and somebody's relying upon that sort of statement in an affidavit to amend a pleading or to say why they took a certain step in a proceeding or to justify the fact they didn't act in a particular way. If you do that, and again some of the cases Adrian referred to, if you do that, you run the very severe risk that a judge will say, no, you can't do that, I want to see what counsel said. And again, people said, oh, well, no, I don't want to do that. But if you rely upon counsel's, the thrust of counsel's advice to justify what you're doing, you run the huge risk that you will find yourself having waived the privilege and you'll have to give a copy of the advice. Some judges, including the judge that Carolyn used to work for, would say it's not fair, and then there is an issue of fairness, because I tried it before him and didn't win. But there are other judges, such as Justice Goldberg, as in the old days. He did make people hand over advice. So again, when you're drafting affidavits, and this goes for the lawyers here, when you're drafting affidavits, never say based upon counsel's advice, or in drafting letters, we've now obtained counsel's advice and therefore we're going to amend the pleading. If you say that, you're effectively giving the thrust of the fact that you've got counsel's advice and counsel says we should join this party or we should amend the pleading and add this defence. People will sometimes say, well, okay, I want to see what counsel said while you're doing it. So, again, that's a no-no. Next point, the briefing point that Adrian made about briefing organisations. Again, in my practice, acting for large corporations regularly, often you'll have a situation where my instructors will give a letter of advice to the corporate counsel that sets out what maybe my view is or maybe what their view is, or a combination of both. And then quite properly, the board or the council or the guiding mind of the organisation will want to get a summary of what council's advice is or what the lawyer's advice is. A summary is at least somewhat better than... There have been examples where copies of advice of my advice or a solicitor's advice have been disseminated as part of a board paper. Now, you should certainly avoid that, because there's a real risk that if the advice is disseminated to all the board members, there must be a protocol in place that they fully appreciate and understand that that document is confidential, and they don't sort of go and talk to their mate on the other side and say, well, look, we've got Roberts' advice and Roberts has told us this, this and this, and so therefore you guys are in clag. That's happened, and if that happens, of course, the advice is no longer privileged. So that the concept of briefing of large organisations, again, is very important, that the person you're dealing with who's going to be doing that you impress upon them that they, in any briefing they give to their corporate mentors, that the corporate mentors understand the confidential nature of the advice that's been imparted. Otherwise, again, from the point that Adrian made, and there are examples of it, you have the problem of privilege being waived. The final point, he touched upon it, and I'll deal with it after Carolyn because I don't want to steal her thunder, is the issue of experts. Often you have these sort of CLE seminars about dealing with experts. Dealing with experts is a very fraught issue in itself. I'll touch upon it at the end and give you an example of how not to do it, in the case I was involved. But I'd encourage at the end, I'll do that at the end of this, and then I'll encourage anybody to ask any questions arising out of what I've just said, or when the other two have said, in a practical fashion. So I hope we'll have time to do that at the end.
Thank you. I'm just going to speak very briefly because a lot of the points have been covered, but I'll just talk briefly about the decision of Justice Armand in the case. If anyone's interested in the citation, it's Lactalis Gindi Proprietary Limited and Gindi Cheese, and it's 2013 VSC 475. A dispute arose out of the sale of... So the business Lactalis bought Gindi Cheese, and a dispute has subsequently arisen. There was the Listeria outbreak earlier this year. There was a business sale agreement, and there was an interesting clause in the business sale agreement which said that there was a deferred payment scheme, but there was also an interesting clause where they said that if before the deferred amount expiry date, the purchaser makes a bona fide claim against a vendor for breach of a sale document. And so it then defines bona fide claim to mean a claim or claims by the purchaser against a vendor for breach of a sale document for which it has obtained a legal opinion from senior counsel with not less than 10 years' experience at the bar that the purchaser has reasonable prospects of success of that claim in a court of relevant jurisdiction. So a dispute did arise, and the vendors, the defendants to that proceeding, issued a subpoena against the plaintiffs asking for counsel's advice. They asked for that advice on two bases. The first basis was that by entering into that sale of business agreement, which required the purchaser to obtain legal advice from senior counsel of not less than 10 years' experience, that in doing so they had waived privilege. The second basis was they actually referred to the fact that they had obtained this legal advice and that counsel had said they had a reasonable prospect of success in not just the writ but the statement of claim. And they said that on that basis as well, they had disclosed the substance of the legal advice. Now, Justice Armand struck out the first basis. He said that he wasn't persuaded by that. He said that it was really, that clause was really setting up the mechanism by which proceedings could be commenced. So until a step was actually taken by the purchaser to commence proceedings, then he couldn't see that they would be taken to have waived privilege. However, with respect to the second basis, so by referring to this legal advice in the statement of claim, he said that yes, they had waived privilege. And it was attacked by way of the Evidence Act, so not on the common law basis. The Evidence Act in particular, so section 122 of the Evidence Act provides that subject to subsection 5, this division does not prevent the adducing of evidence if the client or party concerned has acted in a way that is inconsistent with the client or party objecting to the adducing of the evidence. And in determining whether a party is acting inconsistently, subsection 3 says, without limiting subsection 2, a client or party is taken to have so acted if A, the client or party knowingly and voluntarily disclosed the substance of the evidence to another person, or B, the substance of the evidence has been disclosed with the express or implied consent of the client or party. So His Honour then had to determine whether the plaintiffs had knowingly or voluntarily disclosed the substance of the evidence to another person. And he said, well, clearly they have knowingly and voluntarily disclosed that evidence. So the substance of that evidence, they've put it in the pleading. There's no question that's been voluntarily done. He then had to determine whether he thought the substance of the opinion had been disclosed, and he formed the view that yes, it had. So in saying that they had reasonable prospects of success on particular allegations that particular warranties had been breached, the gist or the conclusion that counsel had reached had been disclosed. So that was enough for His Honour to say, well, no, you've got to hand over counsel's advice. He said, it doesn't matter, for the purposes of subsection 122, subsection 2, considerations of fairness don't come into play. If you've either disclosed voluntarily or knowingly, or acted or have impliedly disclosed, then you're taken to have waived the privilege if you've disclosed the substance. So fairness just doesn't really have a role to play.
Okay. Thank you for that, Carolyn. That's a very useful point to be to draw to people's attention. Again, I'll talk about my experience. Regularly in the context of construction contracts, in particular large construction contracts, you have a situation where the dispute resolution clauses contain provisions such as you have to have senior counsel's advice, or the older ones talk about Queen's Counsel's advice before you take a step or not take a step, or in the event that you get Queen's Counsel's advice that says that there's no reasonable prospect of success, you don't have to take a step. Now, and this is a good example of where that actually came into being in terms of somebody sought to activate a mechanism where advice needed to be obtained before you took a particular action. Now, anybody who finds themselves in that position, and this is probably more likely to be a barrister rather than a solicitor, but it could be a solicitor's opinion as well, you need to be very careful as to how you express that advice. If you are providing advice to a client, you know in that context that somebody is going to do something based upon that advice, it's very important you express that advice in very measured terms. In terms, I'm not suggesting for a moment you should do anything other than express your honestly held view as to what the law is. But it's very important that you do it in measured terms, in terms that you say to yourself, well, if the judge saw this, and I'm looking straight in the eye and say, well, that's my view, because one would expect that, presuming the case runs based upon your view, which more often than not it should, then the fact that you shouldn't be embarrassed by the fact that the advice that you give ultimately is shown to the court. Again, in construction disputes, it is not uncommon that a client might show your advice to the other side at the commencement of a dispute to say, well, look, we've got Robert's advice and Robert says this or Robert says that. And again, it's a question of, I suppose, as you get older and got a bit more grey hair, if you honestly hold the view, you shouldn't be worried about the fact that the other side are going to see it. But you need to be very much alive in that sort of environment that your advice may well find itself being shown to the other side. Against that, and I think Justice Symons was 100%, of course he was 100% correct. Anybody who, there was no need, and that's a perfect example, there was no need for them to plead the advice. So that was a mistake. For what it's worth, I think Justice Symons was wrong to suggest that the advice wasn't producible in the event, but him having concluded that the clause didn't waive privilege, the barrister or the solicitor who drafted that statement of claim in my view, made a bit of a mistake. And that's a useful example of how you can make mistakes. Now, if we then turn to the other point that I wanted to talk a bit about, and that is the briefing of experts. A couple of things. Firstly, I'll talk about how they should be briefed, and then I'll talk about what you shouldn't do. And I emphasise this is just a thumbnail sketch because you can talk about briefing experts and privilege for a whole hour. Even before a decision of Justice Vickers in a case called Rhodes Corporation and Love, it's a decision in 2011, people, when you're dealing with experts, you really should make sure that any time you're sitting across the table from an expert, you must have in the back of your mind that there is a prospect that there is a third person that's effectively looking over you, namely the court. The idea of privilege attaching to expert lawyer communications is a misnomer because your client's paying a fortune for both you and the expert to sit in that room to talk about their dispute. The prospect of the client not using that expert as an expert witness is very low, and as soon as Adrian mentioned, as soon as the expert's report is filed, no privilege attaches to any communication you've had with that expert. Hence, it is absolutely essential from day one that any communication you have with that expert must be on a candid, open basis, but must also be on an arm's length basis so that the expert is not involved in any way, shape or form in designing the strategy of the case. Or if they are, the client understands the risk that you're running, that they may well have to get questions asked in the witness box of the expert saying, well, you were at a meeting with Roberts and the client where you devised the strategy about putting the case this way, or this way, and he has to say yes, and you can't object. And if you do object, you just go red in the face. So it's very important in dealing with an expert that anything that you do or say is done in a measured way so that the expert is kept to a certain extent like a mushroom in the dark as to the case strategy. An example of where the mistake, to show how the mistake can, excuse me, can and often is made, was a case I was involved in about 5 or so years ago. In that case, a plaintiff was running a novel case based upon an American concept of effectively throwing a building contract out and making a claim on the basis of a fundamental change to a building contract or fundamental change of a contractual relationship such that they didn't have to be bound by the contractual measure of cost. That was something that I'd never heard of, and it featured in one expert's report, and then suddenly the other expert started talking about this concept as well. And I thought to myself, well, and these were building experts, and I knew the building experts reasonably well, and I'd never heard them talk about this concept before. And so what we did shortly before trial is subpoena all the experts and got their files. And at that stage, this is before Rhodes Corporations and Love, and everybody thought, hang on, no, it's all privileged. You can't have that. And the answer is, I saw somebody shake their head, that's right, it's not. And so we got the entire file of, after much argy-bargy, and the way it worked was we subpoenaed them, the other side claimed privilege, we challenged the claim to privilege, and went before Associate Justice Daly, and Associate Justice Daly ultimately agreed with the submissions put by me and my junior that basically no privilege attaches to any communication between expert and lawyer, and so we got the entire files. When we got the files, and I'll put this in a careful way, when we got the files, we found that what had happened was that, yes, I was right, that the American expert had come up with this idea, that misconceived junior barrister had run with the idea and had been sending memoranda to the other 2 experts and asking them to weave the concept into their expert reports. And so, and you can imagine the fun I had cross-examining these experts and the damage I did to the case such that we ultimately, after 25 days, it settled as a result of that inappropriate conduct. And this was a case that had run for about 6 years, and the legal costs involved were massive, as you expect. And I ripped it apart based upon that inappropriate behaviour. That's a very good example of what not to do, because and this was before Carolyn's judge, Justice Habersberger, and by the end of it, he was furious. And I've got no doubt, in fact, I know that in part that case was a forerunner to the Rhodes Corporations and Love and the reasons why the Supreme Court, all courts, are so vigilant to ensure that you're dealing with experts is candid and open. And that's the reason I was saying that and in any event, even if putting aside the issue of candid and open, on no account should you do what those people did, but it's also a useful example of what not to do and how not to do it.
Excuse me.
Yes.
Is there a distinction, though, in the Love case, as I understand it, the expert's report that was the subject of the judge's comments?
Yes.
That expert wasn't relied on in the conduct of the case.
Yep.
And he had been retained directly by Love, and therefore no privilege attached. If he had been retained by lawyers and they'd chosen not to pursue his advice or to proceed with his advice and engage alternate expert, then in that case his file presumably would be privileged.
If he's acting as a claims consultant to the lawyer, more likely than not, his file would remain privileged. But it's not an absolute rule, because his file, the judge may consider it's inappropriate if that person has effectively if the lawyer uses that person as the conduit to the expert. So in the same way as that part of the lawyer's file that details the transactions between that lawyer and an expert ultimately is not privileged, letters of instructions, notes of meetings, and all manner of, in the same way the lawyer might interpose the claims consultant because it's highly technical, then the claims consultant, insofar as interaction between that claims consultant and that expert, no, that's not privileged. And then the extent of that, it may well be the interaction between the lawyer and the claims consultant that then gets passed down to that expert may not be privileged as well.
But in a situation where it's the lawyer directly...
If the lawyer keeps control, and effectively it regularly happens where you have what some people describe as a dirty expert, that expert, especially if you're talking about highly technical things, a lawyer can't be expected to know every area of technology. The lawyer will have that relationship is probably privileged.
One of the things that picks up from your question too is some clients have a tendency to want to brief the experts themselves, and that puts that conflict directly in play where the lawyer's not the person briefing the expert. And the other thing to be careful of is the over-enthusiastic client who wants to speak to the expert and email things to the expert, and again that's has the potential to be very damaging at trial. And as the legal practitioners, that's something that depending on the client, but some clients need to be warned about and some clients need to be warned about firmly.
If I could interpose there, the answer to both of those things is, in case I'm involved in that, doesn't happen, for the simple reason that I've seen that goes, you don't allow the client to talk to the expert, and if you're talking about the relationship between solicitor and expert, unless the client really needs to be there, you don't have the client there, because the fact of the matter is that the risk of there being inappropriate conduct, a waiver of privilege, matters discussed that oughtn't to be discussed in the front of people that in the witness box is too high. So you don't allow direct briefing of experts, and for the reason that you may not want to use them, or the questions may be wrong, and you don't allow direct contact between expert and client unless there's an absolute necessity. And if you do, you control it. Any other questions?
Just in relation to the case of Justice Armand, you suggested that you shouldn't put in the pleading, but I have some difficulty with that in the sense that if you had, as I understood the contract, it effectively was saying that there was like a condition precedent to bringing the action. So therefore, as the plaintiff, it's really one of your proofs. You've really proved that this has happened. Why is that not the case?
You don't have to plead conditions precedent in a statement of claim. We've got a case about that at the moment. If you look at the pleading rules, conditions precedent are taken against you in defence. So you let them take a point against you and say, we've got the advice.
But then, okay, they take the point against you. So what, you then given your reply.
No, you don't put it in the pleading. We can say, you get your counsellor to sound and say, I've given the advice, or we've got the advice.
And you're not going to put the proofs when you give your evidence?
The point I'm making, it's a condition precedent. Pleading rules do not require that to be pleaded in the statement of claim.
But you're going to have to prove it.
Not necessarily. The question is whether the point's taken against you. And if the point's taken against you, it's not a willing waiver of privilege, or it's not a willing reliance upon a document. And in circumstances of fairness, the court, I'd be very surprised if the court would say, you've got to hand over the advice. Because the point here was that it was the overt reliance on it in the statement of claim, which you didn't have to do.
But in the reply, the purpose of the reply, one of the purposes of the reply being to avoid taking the others by surprise. If you didn't mention it in the reply, then you're stuck with not having proved the condition precedent.
Well, as I'm saying, if they take the point against you, then you'd have to think about, yes, assuming that, I would still not, in a pleading, rely upon the advice, and if the point was persisted with, well, then you would say to the judge, the advice was obtained, full stop.
The other thing that you'd started to say, Michael, was that if you lead with it in your statement of claim, then there's no question that in my mind, that you've waived the privilege because you've voluntarily disclosed that. But if you're forced to do it in a reply, then you're also in the position where you can say to the court, well, we don't want to lose the privilege that attaches to this communication. If the issue is, was the advice sought and given, then the answer to that is yes.
So Michael, as I'm understanding Michael's advice, he wouldn't put it even in the reply.
No.
Are you saying, Adrian, that in the reply you could put it prefaced by I'm being forced to do this or something like that?
It very much depends on what how the point is pleaded in the defence and what you need to put in the reply, if you need to put in a reply, whether you just simply join issue with the defendant at that point. So the actual particulars of how you do it will change. I'm not suggesting that you need to put it in, but what I'm saying is that at least if at some point you're required to put it in because the court says to you, I'm going to order that you particularise that, then you're in a position to say, well, that's not a voluntary and free disclosure or waiver of the privilege. And so then you're in the circumstances where is maintaining the privilege inconsistent with the position that you've taken, you're in a much stronger position to say, no, it's not. Whereas if you've put it in your statement of claim, then for mine, it's difficult to see how you can then say maintaining the privilege is somehow consistent with having led with it.
Yeah, I've got a case at the moment where specifically, I can't tell you what the case is about, but specifically an advice has to be obtained from a member of Queen's Counsel before you can do something and take a serious step. Nobody's contemplated putting that in the statement of claim. And the point that and it would depend upon the environment, but if you're before a managed list, there is no way in the wide world I put it in the pleading. It'd be a matter I'd take up with the judge and say that such an advice exists. How are we going to deal with this? We're not going to waive privilege. But I certainly wouldn't be overtly putting it in the statement of claim and therefore putting the chin right out. It's a common, and that's the reason I made the point about the fact of being careful how you express an advice that's being provided for that purpose. That if ultimately it does have to be waived because the judge takes the view that you have to because the environment is expressed in such measured terms that and expresses a conservative view that you're not embarrassed by having to disclose it.
Would you put a bare denial in the reply?
No, if it's a managed list, I can't even talk about managed lists. You bring the matter back before the judge before you did that. If it's not a managed list, I'd still make an application to the court probably, because depending upon the nature of the advice, there's an issue as to how we do it. You would bring it back before the court. You wouldn't refer to in the statement that in any affidavit that the advice exists, and you'd say to the court, this issue has arisen, we don't want to waive privilege, how are we going to deal with it? And I think most judges probably would prefer that. because, as I say, Justice Armand gave them the get out, saying that despite the fact the clause specifically said you had to have the advice, the fact that the clause said that, and the implication by commencing the proceeding is that you had the advice, that wasn't enough to waive privilege. It was only because they were unfortunate enough to put it in the statement of claim that went over the line. Any other questions? Okay, well, thank you all for coming this morning. I hope everybody, the topic of privilege is an issue that's vexed, and I hope we've been of some assistance. Thank you.
Thank you.